Intellectual property is the protection of intangibles. So there's basically two kinds of property. There's tangible property and there's intangible property. So you have real estate, cars, things you can grab, right? And then there's intangible property, and that's intellectual property.
Intellectual property is the protection of someone's ideas, their branding, their expression, something that you can come up with in your mind and that you can develop and build in the practical world.
It used to be that most people were producing products. Now the products are the products of your imagination. And a lot of those don't come in tangible forms. And so the protection of those can add to your asset base and the value of your overall value of your business.
Intellectual property can easily be the most valuable asset of an enterprise, whether we're talking a startup or a mature company.
I would recommend to any inventor who has developed some new idea that they really need to protect not only their idea, which would be copyright, but also a way to represent that idea with trademark, and then a utility of that idea, which would be patent protection.
One of the things that's changed in the, what they say post-millennium, right, is that we are changing into a world, especially into a country, more of thought property, more of intangible property than we are about actual tangible things, because we used to be a manufacturer of things. That's how people got rich before. Now we're a manufacturer of ideas.
You look at someone like Microsoft, for example, where most of their products are software-based, and most of those are covered by some form of intellectual property.
The total tangible assets of Microsoft were essentially negligible. The company may have had $200–300 billion market cap, but its tangible properties would have been, in the low billions. Whereas a company like General Motors would just be the opposite. The difference would be largely intellectual assets.
The big companies have so much of an advantage in marketing and in the business world that if you don't have that sort of protection for your ideas, it will easily be stolen and you won't have any recourse. But if you have protection with your patents, your trademarks, and your copyrights, at least you have a tool and a vehicle to go after them.
Sometimes I think in the interest of getting the business off the ground, intellectual property is neglected until maybe we can afford that. But in some cases, you can't afford not to pursue intellectual property and have that as part of your plan early on.
It's important for a company to brand itself, to make the world know who it is and what its products are.
The trademarks, you're protecting brand recognition. It could be a name, it could be a color, it could be a sound.
It can be a word, it can be a symbol, a combination of the two.
It could be a logo.
The trademark is Coca-Cola.
It can even be the product configuration.
Trademark, you have that. If you think about the Coke bottle, that can be a trademark. They've now tried to trademark the shape of the Coke bottle.
The color of a box, for instance, for Tiffany's, is a trademark. So that's not actually a logo, but it is definitely a protectable trademark.
One time at DuPont, I did a study of the most valuable trademarks in the world. And some that would come to mind are Coca-Cola, IBM, Vodafone, and Teflon was DuPont's most valuable trademark.
It's something that customers associate with the manufacturer, the source of the goods or services.
And the whole idea behind trademarks is origin, source, where the products are coming from, where you're getting it, and a consistency and quality of that source. So if I go to the store, I know I'm going to grab this Coca-Cola can and I know it's going to taste a certain way. I'm not going to be surprised. And because of that, I like it.
I recall 30, 40, $50 billion ascribed to some of these marks. Google's mark is probably easily worth that.
And I brought one product here that you might recognize. And so the trademark can take different forms. If I ask you to identify who manufactured this product, just by looking at it, you can probably tell me, correct? And it also has a little logo on the back, the famous Apple logo. This is probably one of the most valuable trademarks in the world currently. And when you see that, or you see an Apple product, you have some visceral response. You have some expectations as to the quality or the characteristics of the product because of your experience with those products, or because of the education or the marketing and advertising that you've seen.
And it's a way to repeat. It's a way to repeat and generate sales. And so because of it, you want to stop others from trading off of that ability to the reputation you've built.
Make sure that you're not picking a mark that a competitor is using.
Obviously, you don't want to adopt and invest a lot of money in a mark that is confusing with someone else's mark, a mark that someone else has established rights in. And so one of the first steps is, when you think of a mark, engage an attorney or do some basic searching to make sure that your mark doesn't conflict with someone else's, a mark that's already in use by someone else.
Trademark rights. Your trademark rights are protected not only with the trademark itself, the registration of the trademark, but also you have common law rights in our courts, so that if anyone should use your trademark in a particular geographic area, you can go to the courts to enforce them to stop using your trademark, or to pay you money for having used and infringed on your trademark.
You need to identify what kinds of goods or services that you're going to be associating with your brand. And there are several different classifications of goods and services.
And so when you go to register a mark, it's specific to the goods or services that you're going to use the mark with.
Companies in different industries can have the same mark. For instance, the term Explorer is a mark for a browser for the internet. Explorer is also a name for a vehicle.
And so it's important, as you refine your search and look at a mark, is to include the different categories of goods that you're likely to use the mark with.
You have to file for a trademark with the trademark office, identifying the specific goods and services you're going to be using.
Well, you can acquire trademark rights in one of two ways. One is simply adopting the mark and applying it on goods or using it with services to identify the source of those services. And you can acquire rights simply by adopting it and using it. Another way you can acquire rights in a trademark is by filing a trademark application with the U.S. Patent and Trademark Office.
Filing for the trademark, the sooner you do it, the better, because once you get a registration, there's a presumption that you have the mark for the entire country.
In most cases, it's important to seek federal registration because that preserves your right to expand throughout the entire United States. Whereas if you rely solely on common law rights, you may not get all the rights that you are entitled to, and you may be bound to your own market territory, or you may limit the area in which you can use the mark.
Let me quickly mention DuPont's Teflon, an invention made in 1949. And it was just a fortuitous event in a laboratory. So the initial intellectual property on Teflon was a patent that ran for 17 years. So we were the only manufacturer of the chemical, the polymer called Teflon. So after that ran out, we of course had the Teflon trademark. Well, the Teflon trademark was worth a fortune because it had become embedded in the public's mind with quality, with non-stick properties.
So by having a trademark and having it registered, you can ensure that only your product and all of the wonderful qualities that you put into your product and all your hard work is protected.
A patent is for want of a better word, a grant of exclusive rights by the U.S. government. And it gives you, the inventor, the right to exclude other people from making, using, or selling your invention.
These exclusive rights allow the inventor to prevent anyone else from making or using their invention without their permission.
The government gives the inventor exclusive rights in that invention for a limited period of time, and in return, the inventor agrees to disclose the invention, all the details about the invention, to the general public, so that that knowledge and information is available for the general public to build upon.
By having that patent, that's how you're going to commercialize your invention and protect your business.
Well, the Supreme Court has said you can patent anything under the sun made by man.
I worked with a lot of those patents. I mentioned Teflon, but I worked on Kevlar, on nylon, on Dacron, on agricultural chemicals, on biotech inventions.
It's an actual property right that they can license, they can sell, they can donate.
The invention has to be new. It can't be something that's already out in the public knowledge. It has to be useful, and it has to be novel. It has to represent enough of an advancement over what's already in the public domain to justify the grant of a patent.
If you have an idea of how something can work, how something can be built, by writing that down into a description, that's basically what a patent application is. You're describing how the functionality behind an idea.
So you can't patent anything that's naturally occurring in nature.
I have one client who recently came up with an idea. It's probably one of the most simple ideas someone could come up with. It's a mechanism for keeping your shower drain free of hair, or to declog your shower drain. And it's a fairly simple idea that they came up with, and were able to file a patent for them. And they're able to go to a trade show, and now they have some of the biggest players in the industry coming to try to talk to them about licensing the technology.
By having a patent, they're able to do that. They can license those property rights to the manufacturer, making a perfect partnership, allowing them to make and use the invention for a fee.
Whereas if they didn't have any intellectual property, there may not even be any discussion. The big companies may just straight up copy and start producing the product.
One of my clients in Texas was an eye surgeon, and he acquired several patents on intraocular implants, so lenses that he would implant for cataract patients. Now certainly he couldn't compete with the likes of Bausch and Lomb, but he described it to me. He said, my patents are my ticket to negotiate with a company like Bausch and Lomb, because, as I mentioned earlier, companies have a duty to investigate and to honor patents, and if they don't, then there are remedies that are available. And that allowed him to send his patents to Bausch and Lomb, and ultimately they acquired his patents for a nice profit.
So typically what I'd recommend is that they perform a diligent search themselves for anything out there, because the patent process is expensive.
Probably at the low end, you're probably looking at about $5,000 up to $20,000 for very highly complex inventions to prepare and get the application on file.
And then down the road, the expense isn't just getting it filed, it's the interactions back and forth with the patent office.
But unfortunately, under current circumstances, it can take as long as 3 to 4 years before you can go from a pending application to an allowed patent.
In reality, a client could be looking at $20,000 over a period of several years to get a patent. That's a lot of money to spend if you're not going to be able to get a patent ultimately, or a very good patent. So the best thing you can do is identify the most similar things there are out there to determine whether or not it's worth the cost. And you can use common existing tools like the Google search engine. They have one of their subcategories in their menu is for patents, and you can do a patent search. It's a Boolean search. Type in the key terms in search. The patent office also has a search engine, uspto.gov. You can go to the patents and you can search for patents that have issued as well as applications that have published. Search for the key terms, look for anything similar, and if you think that your idea is sufficiently different from anything that you can see in those documents, then you may want to contact an attorney and have a search done.
One of the saddest experiences is that we will have someone come in and they've got a great idea, and one of the first questions we ask is, well, have you exploited this idea? Do you have a product that's in the marketplace? And they sometimes tell us, yes, it's been on the market for a couple of years now. Well, in the patent law, it says that you have to file a patent application on an invention within 1 year after the first public disclosure, use, or sale of that invention. And if you don't do that, then you're basically dedicating the invention to the public, and you've lost your right to obtain a patent on that specific invention.
If you think you have a good idea that no one else is doing, it may be worth pursuing it. And even though it is an expensive process, it may pay off. Yeah, copyrights you can file to protect any form of expression. It can be music, it can be literature, it could be a sculpture, a painting.
Copyrights are the expressions fixed in a tangible medium. So what that means is, as soon as I create something, as soon as I write it, as soon as I paint it, I do that kind of stuff, that is a copyright. So copyrights protect things that you create, that you fix.
Copyright is similar to patents in a way in that it reserves to authors or creators of artistic works and literary works the right to exploit those works, and it preserves to them certain exclusive rights, including the right to copy, the right to reproduce, the right to perform, the right to display in public, the right to distribute copies, things like that.
A government-recognized property that enables the copyright owner to be the exclusive writer, publisher, player, portrayer, actor of the copyrighted material.
The real requirement is that you're putting something, an expression, in a fixed media. And so it doesn't really matter what the media is. Anyway, it could be the way you photograph something, alter the photo. Any way that you can form a fixed, tangible product that has your expression on it, you can get a copyright on it.
They're valuable to authors, composers. If they don't get copyrights, if they don't enforce them, they essentially are giving their work to the world.
Copyright automatically comes into existence the moment a work is fixed in a tangible medium of expression. So if I write a book or I write a manuscript for a book, the moment I finish writing that manuscript, I automatically, by operation of law, have a copyright in that work.
So the instant that you place your expression in a fixed media, copyrights are attached and you do have protections.
Now, to preserve all the legal remedies that are available, it's also good to register the copyright with the Library of Congress, and that preserves all rights and remedies that are available under the Copyright Act, if you do that within the first 3 months after publication of that work.
You can file with the office for an actual copyright by submitting a copy of what it is that you put in a fixed media.
The use of a copyright notice is recommended, but it's no longer mandatory. So once you have your copyright by operation of law, you never forfeit that unless you dedicate it, specifically dedicate it to the public in writing.
Trade secrets, they don't get so much play, but they are vastly important.
A trade secret, as the name implies, is something that's secret and that confers a competitive advantage and that's useful in the conduct of your business.
Everybody likes to use the Coke formula as the perfect trade secret. So they put it in different areas and only certain people can see it. There's some people that I know who do certain candy formulas, and someone sits up high in the roof and no one knows what the mix of the candy is. They climb a ladder and they have tubes that flow down into the vats where everybody mixes it. and only one person has access to it, and then they drop those trade secrets down. And trade secrets are great so long as you can keep them confidential.
One of the classic examples is Kentucky Fried Chicken and their secret seasoning.
A trade secret is essentially any valuable information, commercially valuable information, possessed by a business.
The nice thing about trade secrets is it's fairly easy to protect. Well, it's fairly inexpensive to protect because all it requires is keeping it secret and controlling access to it. Now that can be expensive in terms of a large organization and trying to put in place adequate controls to protect the secrecy of that information.
Oh, many things like customer lists. Like if a competitor was able to some way steal a customer list, that's a theft of a trade secret.
As an entrepreneur, you have to take measures to police and make certain that no one is going to have access to that information, and you have to take steps to ensure that that access can't be breached, so that someone could take that information.
The downside of trade secrets is its volatility, because once the trade secret is out there or becomes publicly known, any protection you have evaporates immediately.
A problem with trade secrets is past employees that would take privileged information and may sell it. And that can be a problem with a trade secret. So you have to be certain of who you allow to know the information.
So let's take, for example, a disgruntled employee that posts your valuable trade secret on the internet. You might have a cause of action against that employee, but that secret is gone forever because it's now become public knowledge.
For example, at Coca-Cola, I used to work at Coca-Cola where they have the trade secret that everyone knows about, the Coca-Cola formula. I don't know did not have access to the Coca-Cola formula. So although I would never have breached a trust anyway, I couldn't, if I wanted to, breach that trust because Coca-Cola has taken such active steps in protecting their trade secret.
Well, I'd be very thoughtful about the procedures and protections you put into place in terms of limiting access to that trade secret. You also need to build good protections in terms of contracts with other people that are involved. You know, someone once mentioned to me that the ideal size of a business is one person and two people is half as good, and you can do the math from there. And that really applies with respect to trade secrets, because if it's just you and you keep it to yourself, that's great. But if you bring in other people to help you accomplish the things that you need to do, then you need to think about who needs access to this trade secret, who doesn't, how am I going to control access, and when I invite other employees in, I want to build in adequate protections in my employee agreements and other contracts that I have with business partners and employees and independent contractors.